Good morning. My name is Dr. Julie Clark, and I would just like to say one quick thing before we get started. Being pro se is a obvious burden on my behalf, and all of this is new to me. It's like me trying to be a veterinarian for the first time. And it's a very different thing when you are pleading on behalf of someone else versus when you are pleading on behalf of yourself. And so I feel very, passionate about this. And I also, because of that, I had presented something that I wanted to present to you. And I felt like what was most important in my contention that this is a constitutional issue, that hearing what the defendants actually said was foremost importance.
Do you want to reserve some time for rebuttal?
Possibly. I can go ahead and do that, yeah, I guess I can.
Okay.
I'm not sure that I will need to.
Okay. Well, usually people sort of say what they're going to do beforehand. You can use it or not. It's up to you.
I'll go ahead and reserve it then.
Okay. How long?
3 minutes.
3 minutes. Okay.
Okay.
That means you have 12 minutes here.
Oh, okay. Though in that case, then I will not do it.
Okay.
Okay. Excuse me,
You
sir.
want your full 15
I do
right
want my
off
full
the bat,
15.
and then Mr. Koppel will talk, and then that will be it.
That will be it. That's fine.
Okay. Thank you.
What I don't know quite how to proceed through this. What I was basically going to say is that I was improving 2 homes in 2015. And at that time, I found myself in the middle of a housing boom. And all the trustworthy contractors that I'd used when I first moved here in 2007, which was a completely different economic situation, were no longer available. My daughter, who was a teacher at Harpeth Middle School in Kingston Springs, told me about Mr. Givens because she'd seen him working at the school. And she recommended that next time I picked up my grandson, ask Mrs. Givens, who is the supervisor of the daycare at the school, if her husband did work for other people than just the school district. Well, because of what Mrs. Givens told me, I included her in this.
What did Miss Givens tell you?
Okay, she told me that her husband could do anything that I wanted him to do.
Okay.
And she listed off a few things, like he was licensed as an HVAC and he could do carpentry. Never once did she mention painting.
So she didn't mention anything about painting?
No, but that is not the issue, Your Honor, if I may. The issue is that neither one of them told me that Mr. Givens was claiming to be disabled in a workers' compensation suit with Liberty Mutual over an injury at a previous job. And they were claiming that he was 100% disabled. And a mere 3.5 months before I asked her this, she told me that he could do anything that I could possibly want him to do, but she had told in her deposition, which I included in the court transcript, so I have it in the record, she said that he could only use his right arm when Mr. Huffaker.
What did Mr. Givens tell you about his ability to work?
Okay, let me quickly tell you that exactly why. Okay. When I asked Mr. Givens, he never said anything to me about it. He just said, he didn't say it at the time. He came over, I gave him a list of things that I was curious about doing, which was where Judge Wallace went on the mutual mistake. There was no mutual mistake. I had him bid on a few things. I said, let's start with the painting. It was a huge house. And I said, let's start with that. He said, oh, I'm a good painter. And then in testimony, he says, when his attorney asked him, where did you learn to paint? When I painted over my kids' coloring on the wall. He was not an accomplished painter. But that is not the issue. had complete misrepresentation on the behalf of both of them. They're testifying in a workers' compensation suit that he's disabled and cannot work and ends up receiving $170,000 and being declared 70%, disability on some level. So he gets to my house, he doesn't do the job. I keep showing up, nothing's done. I ask him why, and then he starts telling me he's disabled. He says, I can't use my arm. I can't see good because I had a ganglionic block. And
so the misrepresentation is an omission, then, you're saying? That
absolutely.
He didn't it's not something he said. He didn't say,
no.
I'm the best painter, or I'm the,
well, he said he was an accomplished painter, absolutely.
Okay.
He
So
did.
he says he's an accomplished painter.
Absolutely, yes.
All right, so he says he's an accomplished painter, but your primary focus with regard to the misrepresentation is he didn't tell you that he had physical limitations, which you're saying prevented him from being able to do the job.
It was material to the contract. I mean, if somebody is disabled and they can't complete the job because they're disabled, even his attorney said that he can't use his left arm, he can't grip and hold a paint can.
Now, the trial court judge in this case heard the Givenses testify, and essentially found everybody credible and said that you're all believable, you're telling the truth, that you're kind of talking past each other, but everybody's credible here. And so the trial judge says there was no misrepresentation that was made. And so for the core of your Tennessee Consumer Protection Act claim, you're saying there was this misrepresentation. In reviewing a determination from a trial court where there's a credibility finding and a factual finding, this court's review is more limited than a factual question. So what would you point us to in the record to overcome that finding from the trial court? Because the trial court is entitled to a great degree of deference in terms of those findings.
Can I read you a little bit? Well, I could point to the most blatant, damning thing. When I asked him, Mr. Givens, why he never told me that he was disabled, his response in the record is, ma'am, if I would have told you, you wouldn't have hired me. I mean, he goes on and on about his mentality, if I may project, is like, here's another thing. I asked him in the trial, do you remember ever mentioning to me that you ever had any problems from being injured at that time? His answer was, ma'am, you did not ask. And I said, but you don't remember mentioning it. He said, no, ma'am, I didn't offer it. No, ma'am, I did not, and you didn't ask. Like the burden was on me to discover that he was disabled. And he went on to say, so I asked him, I said, do you feel like your demeanor and the way you carry yourself appears to someone that doesn't know you as if you have a problem? Like if maybe you have a limp or anything like that. Do you feel like most people who would see you would think of you as an able-bodied person? And he said, possibly, yes. My daughter had seen him working at the school, and when I met him, he's a big, healthy guy. He did not look in any means to be disabled. And I actually gave him a job because I'd had so much trouble with contractors that I gave him a job to do with some plumbing. He handled it.
So he handled the first job, and he was clearly and successfully. I mean, that's the reason you hired him for the bigger job. And the trial judge, my understanding here, the trial judge looked down and said, I think he could have finished the job, and that in this case that he was capable of having completed this job. What in the record would show that he wasn't capable of finishing this job?
So 30 days. That's how long he was there. I kept going over, nothing's happening. This is what he had not accomplished. It was a 3-story house. It had an upstairs, a middle stairs, and a basement, and he was also going to paint the inside of the garage walls. So after 30 days, this is what Mr. Koppel had not, sorry about that, Mr. Givens had not accomplished. He had, first off, he'd only done a first coat of paint on the upstairs, which was a loft. It didn't even go the whole length of the house. So there was no second coat of paint on the upstairs loft, which included a recreation room, a very large master bedroom with 2 closets, the entire main floor, which had 17-foot ceilings. I asked him, how are you gonna paint 17-foot ceilings with one arm? And he said, I'll just go up on the ladder, put my bucket on the ladder, and I'll roll it. And I'm like, that could be a liability issue for me. So
Dr. Clark, didn't he reference also, though, using rollers with extension poles as part of how he was going to paint?
With one arm, Your Honor? With the paint sitting on the thing? What if he lost his balance? And that was actually part of the problem. When I first noticed there was a problem, I went over there, and when we got into the problem, it was when he was coming down the first stairwell. I looked up there and I said, what in heaven's name? It was all crooked, and I've owned several homes. I built a veterinary clinic. I know a fine line on a junction of the ceiling and the wall. And it was all over the place. He had paint on the floor. There was paint on my ceiling, which was not going to be painted. And I asked him why. Why was it like that? He said, well, I couldn't see out of my left eye. It's related to the gangliotic block. I can't see well, and I was getting tired. This man is a liar. And that is the problem here. And the problem that I have with Judge Wallace is that my entire case, and I have built a case here, of misrepresentation. He said, if I told you the truth, you wouldn't have hired me. What can that be other than misrepresentation? Judge Wallace, in the first order, never once addressed my issues of intentional misrepresentation and my constitutional right to have access to the Tennessee Consumer Protection Act. Now, I know it's not a happy thing, because I went and talked to several attorneys, and I was told, in fact, by Jack Garnett, the one that went to jail, that nobody will give you a ruling on a Consumer Protection Act. The one attorney I hired didn't know anything about it. He had to look it up for 20 minutes while I sat there. So I feel like I am being denied my access to a law that's on the books of Tennessee.
Dr. Clark, hasn't Judge Wallace, though, and you may disagree with the conclusion, and maybe it's a wrong conclusion, but it seems to me the trial judge said there was no misrepresentation here, that I believe that Mr. Givens and Miss Givens and you are all telling the truth, and that you're essentially just talking past each other here rather than somebody lying. And maybe that's a wrong conclusion. Well, but isn't that a ruling on your Tennessee Consumer Protection Act claim when he says there is no misrepresentation that's
he may say that, but if somebody lies to you about a material factor, it's not like it was an accident. He knew he was disabled. He was in court saying he was 100% disabled. They say that he cannot do any work in the deposition. It's all in there. He says he cannot work. The judge asked him, it was Mr. Huffaker for Liberty Mutual asked her, what does your husband do all day? He sits around, visits his father, maybe brings me a drink, implying he cannot work. So you either are disabled or you're not disabled. You cannot be both. And I'm an educated person. I have hired lots of people. I've never had anybody hire me that I've hired later tell me that they're in a workers' compensation suit, and they're telling that body in a testimony under oath that they cannot work, that they can't lift more than 30 pounds. All of that is in there. There is just no way that this is not intentional misrepresentation. If it isn't, then I don't know what it would take for it to be intentional misrepresentation. There is a material fact. It wasn't like he was telling me his religious beliefs or something. This all pertained to his ability to do the work. And it wasn't done. 30 days. And he had not gotten off the first floor. He'd gotten down that one wall. there was still an entire main floor with 2 bedrooms, a bathroom, a kitchen, a dining room, a living room with 17-foot walls. There was an entire steep base stairway going down to the basement where there were 2 bedrooms, a bathroom. There was an entire 2-car garage that he had yet to paint in 30 days. How long does one supposed to give somebody to paint? When I hired a painter, it was done in a week. You know, he was attempting to do that job by himself, which in and of itself shows his lack of expertise.
Dr. Clark, is there testimony in the record that suggests that he had told you that it would take 6 weeks to complete? I understand you disagree with that, but does the record reflect that he testified that he had told you that it would take him 6 weeks?
Absolutely not. I brought a piece of paper that is in the record that showed my notes. I'm a meticulous note writer. I've had to take records my entire life. In my notes, I said 2 weeks, and I had each job what he told me. And that's what Judge Wallace goes on saying, that there was this 2,000 disparity. In the notes, it says that I was asking about my garage floor because it was slippery and my grandson had slipped on. I said, I want to put something down so the next family doesn't have their child slip on it. And he was telling me his opinions, and he said, if it'd be this, it'd be one thing, if it'd be another thing, it'd be another thing. But it said right on there, 2 weeks.
So you say he told you 6 weeks to do the painting?
No, he told me 2 weeks.
2 weeks. And
Yes.
then after 30 days, it wasn't even half done.
No, it wasn't even.
There's no way
it was
he
a
could have
fourth
even
done.
done it.
He hadn't even done a second coat on the upstairs loft.
Okay.
And so I gave him chances. I'm a nice person. I have 6 homeless people living with me. I gave him chances. I said, you know, he said, I promise I'll get it done. And I'd come back, not a dadgum thing would have been done. Not one thing. He wasn't even there.
Well, thank you. Your time is up.
Okay.
Mr. Koppel?
Good morning, Your Honors, and may it please the Court. I am George Koppel, representing Mr. Givens. I want to stress at the beginning that this is a cross appeal. We are definitely appealing the judge's ruling. Now, this was a small oral construction contract that involved a lot of indoor painting and some other work, cabinet repairs, porch painting, deck and rails, outdoor deck and rail painting, pressure washing the garage floor, and pressure washing the driveway. The contract was entirely oral, and it was for $11,575. $4,500 was paid either at the beginning or during the course of the work, leaving a total of $7,075 unpaid plus prejudgment interest, and that's the amount of our claim. Now, Mr. Givens was entitled to that judgment because Ms. Clark breached the contract 3 times. She was not entitled to terminate the contract, and therefore her final termination of the contract was a breach of contract. He was entitled to the benefit of the bargain, and the benefit of the bargain was to be allowed to complete the job and to receive the $11,575 that he was entitled to.
So you must be saying there were no time limits.
That's correct. And the judge correctly found that they had not agreed to a time of completion clause. And that, Your Honor, is where I was going to go next. So let me move into what the judge actually did rule and what the law is on this subject. There was no time of completion clause, and it was an entirely oral contract. Now, it is not the case that there is no testimony that he said it would probably take 6 weeks. He absolutely said it would take 6 weeks, and he absolutely denied under oath at trial that he had ever agreed to anything like 2 weeks to paint a house that big and to do those other jobs. That's in the record. But the point is, the judge did not rule, and he was correct to conclude that there was no time of completion clause. Where he made a mistake is in ruling that you have to have a time of completion clause. You absolutely do not have to have a time of completion clause. And I think in the history of the United States, no two non-lawyers have ever had an oral agreement in which they agreed to a time of the essence clause, because they wouldn't know what that was and they wouldn't know the significance of it. So they obviously didn't have a time of the essence clause. Now, what is the law with regard to that? The law is that being late or slow in performance of construction work is not a material breach unless there is a time of the essence clause. She admitted under oath there was no time of the essence clause. That's in the record, and the judge correctly ruled that there was no time of the essence clause and no time of completion clause.
Counsel, you and
Yes.
Dr. Clark seem to be on the same page here in terms of the mutual mistake issue. That the trial judge erred here, and correct me if I'm wrong, but it seems like you're on the same page with regard to there wasn't a mutual mistake here in this case. I wonder, though, about the meeting of the minds language from the trial court. And essentially, don't we have ultimately determination, and there's a more extensive discussion about mutual mistake.
Yeah.
But ultimately, didn't the trial judge just decide there really was no contract here, that there had never been a meeting of the minds, that your client thought this was one job for $11,500 or so. Dr. Clark thought it was multiple separate jobs, discrete jobs within, that was for $2,000 less. And they just never got on the same page in terms of what their actual agreement was. So we really just don't have a contract.
Your Honor, I don't think that that is an appropriate conclusion from what happened here. I mean, he worked the whole time until she came in and said, you're off, you're fired, I'm terminating you. And there was not a dispute about the amount of the contract. There was not a dispute that it involved the things I just read out, various jobs, most of it was painting. And what the judge ruled was, incorrectly, and I will explain that, you said it's more than what the mutual mistake thing needs to be fleshed out a little bit. He ruled that not having an agreement on the time of completion was a mutual mistake. Now, I want to stress, before I talk about mutual mistake, I want to stress, the law of Tennessee is that it is not grounds to maintain breach, or it's not a material breach, if there is no time of the essence clause. That being late or slow is not grounds. And a lot of people might be surprised by that, but that's the law. You cannot go in and say, you are going so slow, you're fired, unless you have a time of the essence clause. And there's no doubt that they had no time of the essence clause. How many cases in Tennessee support that conclusion? 3. Madden Phillips Construction Company versus GGAT Development Corporation at 315 Southwest 3rd, 818. That is on page 15 of the brief. Also, Shepard versus Perkins Builders, 968 Southwest 2nd, a 1997 Court of Appeals opinion. Both of those are reported opinions. And finally, the Pew's Lawn Landscaping case, 320 Southwest 3rd at page 252. That's a Supreme Court case, Tennessee Supreme Court 2010. So the problem with the judge's ruling is that what the judge felt, so now I'm going to talk about mutual mistake and why it's not a mutual mistake. Yes, Your Honor.
Did she fire him expressly because he was slow?
Yes.
Okay. She's also mentioned concerns about the way he was going about it could create liability. The way he was going about it wasn't professionally done, but it was none of that. It was just slow.
She so understressed that the judge didn't even make a ruling as to any defect in the work. And I want to also say, and this is not in the brief, but interestingly enough, the Court of Appeals, there's a good bit of Tennessee law in this area. Interesting. I didn't have to go outside of Tennessee at all. There's a Judge Koch opinion in which he says you have to give notice of the defects. You have to go out and say, you see this line here, it's crooked. I want you to fix that. And there's just nothing, there's no ruling by the judge of any defect in work. Her entire complaint was slow and not making enough progress.
Isn't the credibility determined, the same way credibility may cause challenges for Tennessee Consumer Protection Act for Dr. Clark's
Yes.
claim here, doesn't it also cause problems for you here in terms of the existence of this contract? And the trial judge said, I listened to everybody, they're all credible, they all are honest people just trying, and they're just not understanding each other. And Dr. Clark says this was a $9,500 contract that had separate subdivisions, and Mr. Givens says it isn't. I mean, isn't that enough in and of itself to just defeat the claim here that there was an actual contract?
But that's not what the judge ruled. The judge ruled that there was a mutual mistake, Your Honor. And in other words, that he may have said that, but the ruling was, I'm going to rescind the contract. Now, he rescinded the contract. He didn't say there was no contract. He rescinded the contract on the basis of mutual mistake. And that was a legal error. Now, what mutual mistake requires is that the parties have an assumption about the facts, a fact or facts that is incorrect. Specifically, parties, and this is from American jurisprudence, quoted on pages 10 and 11 of the brief, parties share a common assumption about a vital existing fact upon which they base their bargain, and that fact was false, or that assumption was false. And I'll give you an example. Out in California, where they build these houses up where they shouldn't build them because they get the forest fires and so forth, but they'll sometimes build a house up on top of a hill. Well, I guess you can do that in Tennessee too. And both parties assumed there was at least a roughed-in gravel road to the top of the hill. And they made the contract on that basis, and it turned out there was no road. They both didn't check it out. They both assumed there was a road. So it changes the whole scope of the job, and the contractor can't be expected to rough in a gravel road at great expense in order to build the house. And so that's a mutual mistake of fact. Not negotiating clearly to a time of completion is not a mistake of fact. It might be a good idea, but that's not the point. They didn't enter into a contract that had a time of completion.
Counsel, I want to read you part of the order here and,
Yes.
and set me right where I'm going wrong in my understanding of this. The court rules that there was never a meeting of the minds between Dr. Clark and Mr. Givens regarding the monetary contract terms and all the tasks to be performed. And that seems to defeat contract formation. That sentence alone seems to defeat contract formation. If there's not a meeting of the minds over the monetary contract terms and the tasks to be performed, what exactly do we have? How do we have a contract?
Well, Your Honor, I'm not sure that you understand that the court had already ruled in the previous case, and that's what makes this so very
I'm following that. I'm trying to look at this sentence in the order and see how that doesn't. I follow your argument with regard to mutual mistake, but it's and you and Dr. Clark on the same page with this, but this seems to me to tell me there's no actual contract here, and that there's a ruling that there's no meeting of the minds between Dr. Clark and Mr. Givens regarding the monetary contract terms and all the tasks to be performed. That sounds like there's no contract whatsoever.
Well, but work was done, you see, and you have a contract can be formed, a unilateral contract can be formed. You know, if you go out and paint my house, I'll pay you $11,000. And all he does is go out and paint the house. That forms a contract.
Isn't it's $4,500 here that ultimately the trial judge decided this was worth the value of?
Yeah, of what he had already been paid. So he gets nothing.
Right? Isn't that consistent with the determination there was no contract? I mean, he gets the expenditures that he's had in terms of materials. He gets time for his work. I mean, the computation is consistent with the determination that there's no contract.
I don't think so. It was an $11,700 job, and he testified that he bid it on that basis because remember what happened. The first time she breached, she came out and she said, I've got a new son-in-law. I'm going to let him do the outside decks and porch and rails and so forth. You just do the inside painting. And he said, Ms. Clark, I didn't bid this job in that way. I bid the job because I needed, the profit that I got out of it was based on doing the whole task. And you're taking part of it away from me. But he kept on working. Sounds like, you know, I mean, how can we say that this is not a contract? So then she comes in, and she didn't come in. She sent a man over. Can you imagine this? She sent a man over there, and Mr. Gibbons says, who are you? And he says, well, I'm here to finish the painting. You're apparently fired. She sent me over and said, you finish the painting. And he was trying to, as I said in the brief, trying to make something out of this tattered contract by at least doing the cabinet repairs. And then she comes over finally and says, no, you're fired. So she breached it 3 times, and she admits that he was not an employee. She admits that he was an independent contractor and that she terminated him unilaterally. Now, they had some sort of meeting of the minds there that he would continue, for example, with the cabinet work. He told her, he said, can I at least finish the cabinet work? And she said, yes, go ahead. And then she breached that, 3rd time breach. So no, the only basis, I believe, for the judge's ruling was that he felt that they had made a mutual mistake because they hadn't been careful enough to agree on a time of completion. And the law of Tennessee, as the Court of Appeals from the Western Section ruled in the first case, that is not a mutual mistake. And there's no need for parties to have a time of completion clause. And there was no finding whatsoever that the 2 weeks was agreed to. She testified it was 2 weeks. He said, I never agreed to any time, but I estimated for her that it would be 6 weeks. That's the testimony, and the judge didn't contradict that. And we do not claim that there was any error.
Evidence in the record as to this painting job being that he told Dr. Clark this was going to be the greatest painting job that had ever been completed on the house? And what's the record going to reflect in terms of what Mr. Givens told Dr. Clark about the job in terms of the quality with which he was going to perform it?
You don't brag about painting a house like you do painting a portrait. He just told her he would do the job. Right. That's what he testified to. And he does have to paint with his right arm only. But you can dip the paintbrush or the roller into the paint and then do it with one arm. And that's what he was doing until she interfered with it and took that away from him. Well, I see my time is up. Thank you.
Thank you. Thank you both. And that completes the docket for the morning. Would you recess court, please?